All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in our civil number 17-32, Campbell Law Group Chartered versus Monica Jagelski et al. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. We've read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Thank you, Your Honor. May it please the Court, my name is David Abney. I'm here today with Rick Berry, and we represent Campbell Law Group Chartered. I'll probably usually just refer to them as Campbell. We're here today because Campbell is owed money on a judgment and has been trying to collect the money. Trying to do that has been chasing the pea in the pea and shell game, and it's not worked out very well. The trial court has essentially said that the Uniform Fraudulent Transfer Act doesn't apply here. We submit that it does and it should. As part of the program to hide the assets, conceal the assets.
Well, let's say we agree with you on the issue of fraudulent transfer. Where does it get you?
It gets us the ability to conduct further proceedings to track down exactly what happened to the asset and the proceeds from it.
That's a modest goal at this point, to conduct further proceedings. It seems like there have been plenty of proceedings in this case. And even if the transfer was fraudulent, it seems that your client has multiplied these proceedings by choosing to assert remedies that simply don't exist. I mean, I can find no authority for trying to declare yourself a member of an LLC merely because you have a charging order, for example. And
you're referring to the effort with the Corporation Commission to have them.
Yeah, I mean that strikes me as a wasteful enterprise. Maybe you can tell me why it isn't.
Well, it was inventive in a sense, but it immediately failed.
I love that word.
The Corporation Commission didn't take the documents. And so within 2 weeks, that whole effort fizzled out because the Corporation Commission refused to accept the documents.
Well, but then that wasn't just a fizzle after a couple weeks. It was then litigated.
Well, the issue then was litigated, that particular issue. But the important thing is to try to find out what happened to the original undivided 1/3 in real property in Pinal County.
Well, we can focus on fraudulent transfer in a second, but would you concede at this point that the effort to be declared a member of the LLC was ill-advised?
Not exactly.
Any legal authority to support it?
Yes. In the sense that in this sort of situation, if there are charging orders and if there has been fraudulent efforts to conceal assets, then there is an ability, at least under some authorities, to go in and basically to take over the limited liability company.
What authorities?
The authorities we cited in the brief.
Well, what's your best? I mean, as I read the statutes, literally, which is I think the right way to read statutes, I don't see any authority for it, and I've not seen an Arizona case that has dealt with this factual scenario before.
I don't think there is an Arizona case, and the authorities are the Florida case, the Ninth Circuit case, and the other cases that we cited in the brief.
So there's no binding authority that allows this. Okay.
No, Your Honor. And it was a failed effort. And it failed almost immediately, and then after that it was discussed at the trial court, but the trial court came to the conclusion that you seem to have come to, that it was something better not tried.
I don't mean to project a conclusion. I test various theories to see if I might be missing something, but it does seem that inventive is a good euphemism for that effort.
Well, it may be an accurate adjective and not just a euphemism. It was, you're faced with a situation where the debtor keeps scuttling around, hiding things and transferring things around. You try to figure out how do you deal with that situation.
Well, one way that doesn't seem to be at issue here is veil piercing, and I'm wondering why that's not at issue here.
I think I missed a word there. You said
Veil piercing.
Ah.
I mean, let's assume for a moment that you're right and that this was a classic fraudulent transfer.
I'm very happy you brought up that, Your Honor.
Well,
May I search for the something that ties in with what you just said about veil piercing?
sure.
I didn't think it would come up, but there is a case of Butler.
The only reason it's coming up is not so that we can encourage further litigation. I'm just trying to understand why this relatively straightforward collection matter took the tortured course that it has taken so far.
Oh, I think part of the problem is the trial court did not think that this was a Uniform Fraudulent Transfer Act situation, and it is.
Okay.
But the veil piercing thing, my colleague had given me a copy of this case from our Supreme Court, Butler Law Firm versus Higgins, February 22, 2018, and it talks about veil piercing in relation to limited liability companies, and indicates, at least on my cursory reading of it, that you can't do it for some reason. So, as I said, the Butler Law Firm versus Higgins, February 22, 2018, Arizona Supreme Court.
I'll certainly look at it, and it's an interesting point, but I don't think it's actually before us today. So.
Well, that's what I thought when my distinguished colleague brought it to me. I thought, that's interesting, but I don't know if it's going to come up.
But if that's a 2018 case, it still doesn't answer my question as to why the case is in this posture and not that posture. Because if there is a rule as counterintuitive as you suggest now, as of the last several weeks, it doesn't explain why it wasn't pursued in the last year or two.
I don't know. It seems like a sensible alternative theory to me. I have no problem with that. But you have already a mechanism in place with the Uniform Fraudulent Transfer Act. You should be able to use that, track down what has happened to the asset, which has apparently been converted into money, and find out where the money went, and undo things to the extent you can, and get the money that Campbell is owed. And that's really what this is all about.
But how do you get to that point? I mean, let's assume again, this is a fraudulent transfer. The interest under statute that your client has is that of an assignee of a member. And if we agree for a moment that divesting the LLC of its value to avoid a creditor is, in fact, a fraudulent transfer, I don't see how that translates to a remedy. It's an interesting point along the path of the case, but is it a Pyrrhic victory? Where is the case that ties that to an actual remedy for your client?
Well, the Act itself provides a remedy. If it was indeed if it was indeed fraudulent transfer, then you can undo it. And at the very least, you have mechanisms under the UFTA to track down the asset, where it was, how it was converted, and get the money back.
But if you undo the transfer, that means the property goes back into the original LLC where it sits, and if no distributions are made, your client isn't profiting.
Well, it can't do that anymore. Our understanding is, and pardon me for stepping sideways as far as the record is involved, the original asset was a 1/3 ownership in land in Pinal County. It's been sold, and money has now been distributed to wherever it went. So the land, the original asset, is not there anymore.
Okay.
Well, you're going to have a fascinating situation at the trial court working up the remedy for this. You know, what happened? When did it happen? What can we undo equitably? And where do we get the money then to pay off the debt that's owed to Campbell?
That's helpful.
And that's really all we're asking for. You know, there's many layers and directions that this case went at the trial court. And if it had focused just on the UFTA problem, it would have been a lot cleaner thing to understand and to deal with. And that's really, I mean, of course, there were charging orders that were violated. There were interesting transfers, Empire to another LLC, and then back from that LLC to Empire, and then from Empire to another LLC, and then we lose track. Because without the UFTA to give us the ammunition we need, we can't blow anything up and find out what the truth is. And that's really my argument, is that Jagelski was insolvent. She was in control of what happened.
Well, okay, let's talk about insolvency. You can allege that as a matter of fact, but the law that you seem to rely upon requires an adjudication of insolvency, and I don't think there's been one.
No, there should. Well, it doesn't say who makes the adjudication, whether it's a bankruptcy court or some other court.
Well, but an adjudication is certainly not made by an allegation.
No, it hasn't been. But the Uniform Fraudulent Transfer Act, it doesn't talk about that. It talks about insolvent if the sum of the debts are greater than the debtor's assets, and insolvent if you're generally not paying your debts as they become due. And she admitted, I can't pay this.
Sure.
So
well,
she's insolvent.
I think you can allege that and not have any Rule 11 problems, but but does it, given where we are today, in the case we have to decide, does that translate into any remedy, or does that just translate into further proceedings? Are you foreshadowing allegations for the future?
Well, it's not an allegation when she says on the record and at depositions and in her own documents, I can't pay this.
It's not an adjudication either.
No, that's not an adjudication, but on the UFTA, what you need to find out, are you insolvent? And if you're insolvent, or what you're doing is going to make you insolvent, or if you're acting with intent to defraud creditors, then the UFTA applies, and you follow the various remedies and procedures of the UFTA. Like I said, if this had just been a UFTA case, even if the trial court got it as wrong as it turned out it was gotten wrong, then you just go forward with all the procedures that the UFTA provides for a situation where somebody is trying to do this sort of thing. I've never seen anybody I've read about this in novels like Tom Clancy novels and John Grisham, where people transfer things to these corporations and back around. It's strange to see it in reality, how amateurish it is, and it really, the court needs to step in and say, hold on, what you're doing is wrong on the UFTA. We need to.
On the TV sometime.
Maybe I should. I lead too sheltered a life, I fear. But that's really the heart of my argument. I mean, I could stand up here and babble as I usually do, but I prefer to let a colleague across the aisle take my place and address the court at this stage and reserve my time.
Thank you, Counsel.
Thank you very much.
This is Lawrence Slater, and I am representing Monica Jagelski et al., and that would also include some of those LLCs, Southwest Mancor and Empire Vista. And there may be another one, Northern Mancor. I don't know if you guys question one side and then you take the other, but I was intending today to go through the lack of authority for Mr. Campbell to take over the LLC.
Well, given the thrust of the appellant's argument, you might do well to spend some time on the fraudulent transfer issue.
Okay. Yeah, because as I looked through, they relied on a Florida case, which they say allowed them to take over the company, but in Florida, they can levy on the LLC, and it's not required that there's an exclusive remedy of
a lot of things would be different
of the
if we were in
charging order,
Florida,
and also
but
they
we're
relied
not. So
they relied on
I think we can move on.
Yeah,
Yeah.
And specifically, I think it would be helpful if you could tell us how the various transfers of corporate interests were not fraudulent transfers.
right. Okay.
They certainly looked
Yeah.
like they were undertaken to avoid payment of a debt.
Well, there's one thing if you say I'm transferring assets from one LLC to another, and my intent is to hinder and delay a creditor, but what if the creditor is doing wrongful things? Then can I do the transfers? Is it different?
Well, if the debt is a valid debt, you may have a remedy against the creditor for improper debt collection practices, but that doesn't mean you commit fraud to avoid the debt.
Okay, but holding your thought, I'm reading from the decision of the judge in the trial court from the August 26 minute entry, and he says the judgment debtor testified that the transfers were prompted by her understanding that the judgment creditor was improperly seeking to substitute itself for her as a member of Empire Vista. And so I'm saying, in my book, he can't do that, but he was doing it. And so does she just sit by? Because as you know, the courts are slow. This was April 1st of,
Well, the Corporation Commission rejected the effort.
okay, but what he'll do tomorrow or the next day?
Well, I think what the creditor will do tomorrow or the next day is try to collect on a judgment, which is
Okay.
actually what's
Okay.
supposed to happen.
But he tried to substitute himself in the LLC, and so the facts you have are that on
Did that
April-
LLC, I'm sorry, but did that LLC have any business other than as a holding company for the interest in that property?
Right, that was it,
That was it.
yes.
So was it some reaction to the an affront to the structure of the LLC statute that prompted this, or was it really that she didn't want the debt paid? Because as I see it, even if this remedy had been achieved through a statutorily improper means, the damage from that improper means would have been the collection of the debt that frankly should be paid.
Okay, so here's how I'd see it. She, being Monica Jagelski, she has an LLC, the LLC has an asset, and there's a charging order, and the creditor cannot get at the asset. Okay? His exclusive remedy is if she takes a distribution, then he can grab it, but otherwise there's no remedy. And April 1st, 2016, he gets the charging order that morning. Okay? And it's in your facts. That afternoon, he takes his articles and he goes to the Corporation Commission and says, I am filing these papers with you to become the member of the LLC, and I'm the assignee. She was adjudicated insolvent. He says these things in his papers that he filed.
Right.
Also that day, as you know, there's a property. Empire Vista is a 1/3, and then there's also a 2/3 owner. He goes to the 2/3 owner, and he says, I am now the owner of Empire Vista. Here's my Corporation Commission. Okay, so you got it. And
I
I
get
want
that,
the money.
but that sounds to me analogous to an argument that says if somebody brings a meritless lawsuit against me, my response is not to defend the lawsuit and get it dismissed and seek my attorney's fees, but instead just to secrete my assets away. And I don't think the UFTA
Okay, but let's talk
contemplates
about
that.
what she did, though, in secreting the assets away, okay? But the problem we have in the trial courts, eventually we got an order, and the order was given on August 4th, and it's number 224 in the exhibit list, where the trial judge ordered him, don't make any efforts to be collecting on this until I sort out whether you can take over or not. But so from April to August, it was the law of the jungle. Maybe he'll file again. Maybe he'll do something else. Okay, and
TROs are for, isn't it?
to do what? To order him not to try to take over the company? Or,
To get that result more
okay.
quickly.
So what the judge said in the trial court, and this is again on the August 26th, the property was an asset of the LLC, not an asset of the judgment debtor. The LLC was free to transfer the property as it saw fit to do. The judgment debtor's asset, its membership in the LLC, remained the same both before and after the transfer of the property. So if she is a member of Empire Vista, and then after the transfer, she's still a member of Empire Vista, and she's a member of Southwest Mancor, and Southwest Mancor is now holding the land ownership with a carryback to Empire Vista. To me, there's no fraudulent transfer. She is still the owner of the asset as the member.
This analogy may not ring true with you, but it sounds to me almost like somebody who is free to sell their home, even though there's a lien on it. They're free to sell the home, just decides to burn it down.
Well, okay, let's say she does burn it down. Now there's no home, okay?
Well,
In our
that's-
case, there's still a
isn't this
home.
transfer effectively burning down the LLC?
No, because before the transfer, she owns an LLC that he can't do more than a charging order, and it holds assets. After, she holds two LLCs, and between them, they hold the land and the note. So before and after, the home is still there.
Before and after but she acknowledged, if I'm not mistaken, that she created these transactions in response to the debt collection efforts.
In response to a wrongful thing, he's trying to take ownership. If she now has it in the second LLC that she still owns, he can't run to the Corporation Commission and
Why not? Why can't he do that?
because he doesn't know it's there at the moment until we address it with the judge.
Well, if you're saying that this is okay because he can't get a charging order against an asset that's hidden,
Right.
that doesn't bolster your case under the UFTA.
Okay, I'm saying he was not entitled to take over the LLC.
Okay.
And so this was a self-help remedy she used, so that even if he somehow took it over, he still wouldn't have had the asset. We still would have had to go back in court. And at the end of the day, the transaction didn't diminish her asset ownership.
I've heard now two very interesting characterizations today: inventive and self-help remedy. The UFTA seems to preclude such self-help remedies.
Well, if at the end of the day she has no assets, but at the end of the day she has two LLCs and they've got charging orders against them both, and so their position is completely unchanged when all these transactions are done.
Okay.
And like you were saying to him, even if there is a fraudulent transfer, what are they going to do? Go back from the second LLC to the first? They still have no ability to collect unless she takes a distribution to herself.
Well, it may actually be a Pyrrhic victory, as I pointed out, but if you track the language of the fraudulent transfer statute, sort of clause by clause, this fact pattern seems to fit that language fairly well. And I don't know if you'd like to go through that exercise or if you have another argument you want to make, but we can.
Yeah, the other thing I'd point out at the trial judge, because we're on an appeal status, we're reviewing what his decision was, and the trial judge says this was not her transfer. That's why the language, the LLC free to transfer the assets, because it wasn't like if she owned the land and then she transferred it away, there's your fraudulent transfer. Before she had the land, afterwards she didn't have the land. But if she before owns an LLC, then the LLC makes a transfer, she's free to do that. And that's what this judge says, and I see that as a fair statement of the law. As long as at the end she still has the ownership of the asset.
Well, okay, if we go then to 44-1004 and really track the language of the statute, because I don't want this to sound like a rough equitable determination, but I'm trying to look at what the legislature said. We start with the definition. A transfer is every mode, direct or indirect, absolute or conditional, voluntary or involuntary, of disposing of or parting with an asset or an interest in an asset.
Okay. So that I'm good with that.
So would you agree that this was a transfer?
I'm saying that at the end of the transaction, we still had the same interest that we had before.
I know, but would you agree that this is a transfer? Does it meet the not fraudulent? I'm not asking you to acknowledge that, but do you agree that it's a transfer as the statute defines a transfer?
I have to tell you, I don't have it in front of me, but some of these fraudulent transfer statutes do say transfer by the debtor. Okay, and this is not a transfer by the debtor, and
This one includes an indirect.
Yeah, this doesn't say that. This says direct or indirect, absolute or conditional, voluntary or involuntary. So
Okay.
Would this be a transfer?
This is a transfer.
Okay. So if it's
Whether it comes in there, I'm going to say I don't know, but okay.
Yeah, all right. So if it's a transfer, then we go to 1004A1, which says that a transfer made or obligation incurred by a debtor is fraudulent.
Made by a debtor. Yeah. Okay. I say that's not a transfer by a debtor, but okay.
Right, except we have that direct or indirect language in the definition, and the debtor here actually is the one who directed the transfer, if I'm not mistaken. If I am, please correct me now.
She's the member, right?
Okay. So if the debtor made the transfer with the actual intent to hinder, delay, or defraud any creditor, I would say it's safe to say that this transfer wasn't made with the object of facilitating collection of the debt. Would that be a fair statement?
Okay.
It was made in recognition of the debt collection efforts. And
Okay.
and so,
But the efforts
at
that I'm
that point,
saying-
was it meant to delay?
I draw
or
the
hinder?
line because, as the trial judge said, and I agree, that he was trying to substitute himself for a member of the LLC, and if she hinders that effort, that to me is fair. That's not a legitimate effort to collect the debt in my book.
Well, and I understand the equitable argument there, but just looking at the language of the statute, it doesn't say intent to hinder or delay absolutely legitimate debt collection efforts. It just says hinder, delay, or defraud any creditor.
If she had an asset in her house and he came with gun and knife to rob her, and then she moved it to a different house, you're going to say, by moving the asset, it was a fraudulent move because she's hindering okay. I'm saying this is a wrongful thing he did.
I appreciate the analogy.
Okay.
I think I understand what you're saying.
Okay. All right, but go ahead. Yes. So I'm saying you're reading to me. I'm saying I don't see that applies. But
Okay. No, I think we went through the language, and I understand your gun analogy,
okay.
which is a helpful argument.
It's a wrongful thing. Another way of doing wrongful things. Okay. So I guess I'd want to say too is that on our side we did have an award of attorney fees on the garnishment side. So part of the claim is subject to a claim for attorney fees. I don't know that the ownership one, maybe not, but the fraudulent conveyance claim was made in a garnishment proceedings where the prevailing party was our side, and now they've appealed that, and I believe we still have a claim for attorney fees. Okay, thanks.
Thank you, Counsel.
Seems to me that if we win on the Uniform Fraudulent Transfer Act aspect of the case,
Well, let's stop at if. That wasn't a bad argument.
no, it wasn't. We may be able to.
How would you respond to it? I mean,
Talk about the attorney's fees part? Or
No, I'm
coming
talking
with the
about the
knife?
argument that the transfer was made to avoid an unlawful takeover of an entity rather than to avoid the creditor's actual rights.
Well, my old ears may have misheard you, but I thought I heard TRO go by in the discussion. And what you do is, if you catch wind that somebody is doing something like that they find to be so dangerous, you go to the court right away, the court you're in, and you say, well, I want a TRO to stop this right now.
Well,
and freeze things.
That thought had certainly crossed my mind. I think I was the one who uttered those three letters, but nonetheless, is the purpose of the fraudulent transfer statute served if the transfer is made to avoid an unlawful act?
Yeah, well, I'm not well.
I mean, the gun analogy is a little
Literally,
dramatic, but it does make a point.
Yeah.
Is that so out of place here?
Yes, it is out of place because, first of all, it wasn't something that extreme. Second of all, you had easy remedies, available remedies. Go to the trial court right away and say, we need to stop this. This is wrong. It turned out it was a false alarm. So it turned out you have an alarm that somebody's outside your door with a knife or gun and going to do something, and there's just nobody there at all. Again, the Corporation Commission killed this in its infancy, and it never went anywhere.
Well, your client seemed unwillingness to accept the Corporation Commission's decision and pushed for this.
Well, isn't that what courts are about? You go to the judge and say, we think this is a good idea and we should go forward with it, and the judge says, well, that's either a great idea or that's baloney. But in this case, the fundament of what we're dealing here is the Uniform Fraudulent Transfer Act, and what she did in reaction to a perceived threat to the asset was to shuffle the asset around and has now gone into oblivion. We don't know what's happened with the asset or with the proceeds of the asset. And that's what the UFTA is there to unravel and allow discovery and allow corrective action when you get in that sort of situation. But to immediately start this pea and shell game, which either they were right about this effort at the Corporation Commission and all that effort would have been wasted, or they were wrong and nothing happens.
Given that the asset wound up where it started, is there a fraudulent transfer? I mean, there may have been a fraudulent transfer for a few days, but
It didn't
at
wind.
the end of the day, does it matter if there was a fraudulent transfer?
It does matter. It didn't wind up where it started. The asset went from Empire Vista to Northern Mancor, and then right back to Empire Vista, and then it went to Southwest Mancor, and we lose track of what's happening at that point. Apparently, it's been sold and converted to money, and we don't know what's happened to the money. So we need to track it down. It went back and forth. It bounced back and forth, and then it went someplace else. And we want to find out where it went and what we can do about collecting it. There's going to be a fair amount of work at the trial court, hopefully, after a remand in our favor, and we can unravel all this and get this back on track and try to get the debt collected. But the reaction here was not the reaction of somebody with clean hands. Of course, you may say, well, they had unclean hands at the Corporation Commission, but
It would be a persuasive argument if
it'd be an inventive argument. But at the very least, there has been a violation of the UFTA. This was done with intent to defraud. On pages 20 and 21 of the reply brief, I go over a number of areas in the record where Jagelski says, I did this, quote, to protect the assets. I had the asset transferred. And even in the response brief, it says that she had the LLC transfer the property. She was in control of it. She's a debtor in control of property, and she tried to hide it. And actually, so far, she's been moderately successful. But it's time for that success to end. That's why the UFTA is there, so that debtors have a fair chance to collect the money that they're owed.
And was that indeed the trial court's only reason for failing to find the fraudulent transfer, was because it was the LLC that transferred it?
I think there were subsidiary reasons, about concern about whether she really was insolvent or not. But there were some other backup reasons. But if you track the statute,
But I mean, the trial court did not rule that it was not a fraudulent transfer because it was a good faith attempt to avoid a bad faith move by the creditor.
I don't think so. No. I had a hard time understanding what happened. I worked on this for quite a few weeks, and finally, we figured this out, and did the reply brief and whatnot. But it's an interesting situation. I haven't seen anything like it outside of the fiction that I've read, which is probably all outdated. But if there's no further questions, I will escape to my seat and cede my time to the court.
Thank you, counsel.
Thank you for your attention. I appreciate it.
We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.